10 New Driving Laws 2026. Immigrants getting arrested. Critical warning. Visa status radar. YouTube script. 2,800 words. The traffic stop lasted 11 minutes. 11 minutes that began with a broken tail light and ended with an immigration hold. A man who had lived in the United States for 9 years, working, paying taxes, raising a family, sat in the back of a patrol car watching his car get searched while his wife stood on the sidewalk with their 2 children, not understanding what was happening or why it wasn't stopping. The officer's flashlight swept across the back seat. Another officer ran the license. A third was already on a separate radio channel. This didn't unfold over a long investigation. It unfolded in 11 minutes. 11 minutes that could end a work permit. 11 minutes that could trigger an ICE detainer. 11 minutes that could separate a father from his children for months or permanently. One wrong response to one routine question, and a traffic stop becomes the first step in a removal proceeding. What is happening at traffic stops across the United States in 2026 has shocked immigrant communities, alarmed legal advocates, and exposed a set of new and revised state driving laws that are operating as de facto immigration enforcement tools. The laws changed. The integration between local police and federal immigration authorities changed. And most immigrants, documented and undocumented alike, have no idea how much risk they are carrying every single time they get behind the wheel. Most people think a traffic stop is just a traffic stop. They answer every question. They hand over every document asked for. They fall straight into the trap. But today, you're going to do something different. For several years now, there had been signals, not from official DHS announcements, not from state legislative summaries most people read, just signals, that states across the country were preparing driving law frameworks with immigration consequences more severe than anything in recent memory. State legislatures had been active in this space quietly, yes, but also with increasing coordination in that approach. Bills that appeared to be about road safety were being written with provisions that directly intersected with federal immigration databases. Their actions followed a pattern, a legislative pattern, a policy pattern, almost a deliberate design, that immigration attorneys in high enforcement states began tracking with growing alarm through 2024 and 2025. But what triggered open alarm among immigrant advocacy organizations this year was that the pattern stopped being a collection of isolated state actions. It became a national enforcement reality. Attorneys who monitor immigrant driver safety recognize the indicators. The expansion of state laws requiring proof of lawful presence to obtain or maintain a driver's license. The legislative rollback in certain states of laws that had previously allowed undocumented immigrants to obtain driving privilege cards. The formalization of data sharing agreements between state DMVs and federal immigration authorities. The sudden integration of license plate reader technology with ICE's investigative case management system in multiple jurisdictions. And when traffic enforcement infrastructure gets connected to immigration databases without public education about what that means, the people stopped at traffic lights pay the price. In early 2026, state legislative records, court documents, and investigative reporting confirmed what legal observers described as a formalized coordination structure between local law enforcement and federal immigration authorities, including traffic stop protocols not seen in their current integrated form in over a generation. These are policy shifts that only happen when the enforcement posture is changing at a fundamental level. A signal that routine traffic stops are no longer simply traffic stops in certain jurisdictions. A signal that driving without a valid license is being treated as a trigger for immigration status review, not just a traffic citation. Or a signal that the firewall between local policing and federal immigration enforcement has been structurally lowered in ways that affect every immigrant driver. Legal observers weren't certain which framing was most accurate, or whether all three were simultaneously true. But one thing was clear across documented cases in 2026. For immigrants, regardless of status, the act of driving had become a meaningful legal risk in a way it had not been before. And when driving becomes a risk, the community that depends on driving to survive carries that risk every single day. The alert issued by immigration attorneys, civil rights organizations, and immigrant community groups in 2026 was not routine. It was not a public education campaign. It was urgent and operationally specific. Attorney after attorney described the new enforcement landscape as sweeping in its geographic reach, disproportionate in its impact on immigrant communities, and most importantly, invisible to the people it targeted most because the law changes happened in state capitals, not in federal immigration courts. The National Immigration Law Center, the ACLU, and regional advocacy organizations issued detailed guidance. Their collective response was among the most comprehensive traffic and immigration intersection warnings seen in years. Because the 10 driving law changes documented in 2026 are not theoretical risks. They are active enforcement mechanisms that have already produced arrests, detentions, and removal proceedings, starting with nothing more than a broken taillight. Legal advocates and court records confirmed that the new driving law enforcement landscape had produced immigration consequences across multiple states, targeting immigrant drivers who were unaware of law changes, including individuals whose driving privilege cards had recently been invalidated by state legislative action, and who continued driving based on the previous legal framework. Officers targeted drivers during routine traffic stops who presented non-standard license documents. They targeted individuals whose license plate triggered a DMV immigration database flag. They targeted people with prior minor traffic infractions that, under new state sentencing frameworks, now met the threshold for immigration-relevant criminal activity. This wasn't a crackdown announced in advance. It was a quiet enforcement shift with immediate consequences. And that's what made the 2026 warning so critical for every immigrant family with a car in the driveway. Let me walk through the 10 specific driving law changes in 2026 that are directly affecting immigrant communities, because understanding each one is not optional. This is the difference between a ticket and a detention. The first change is the rollback of driving privilege cards in multiple states. Several states that had previously passed laws allowing undocumented immigrants to obtain driving privilege cards, cards that allowed driving without requiring proof of lawful immigration status, have reversed or restricted those laws in 2026. In those states, individuals who previously held valid driving privilege cards are now driving without valid documentation. They may not know the law changed, their card may not have expired yet, but if they are stopped, the officer's system will show their authorization as revoked. And a revoked license, in states with enhanced immigration enforcement coordination, is now a trigger for further inquiry. The second change involves new documentation verification requirements at traffic stops. In several high-enforcement states, legislation passed in late 2025 and effective in 2026 requires law enforcement officers to verify the immigration status of any driver who cannot produce a federally compliant, real ID-compliant license or state-issued identification. A foreign driver's license, which many visa holders use, does not satisfy this requirement in those states. A passport alone does not satisfy this requirement in those states. The only document that fully protects you from further inquiry in those jurisdictions is a real ID-compliant driver's license or a valid U.S. passport used in conjunction with a valid foreign or international license. If you are using documentation that does not meet the new standard, you are exposed at every traffic stop. The third change is the expansion of what counts as a disqualifying offense for a driver's license in states with lawful presence requirements. Several states have updated their statutes to include civil immigration violations, not criminal convictions, civil violations, as disqualifying conditions for driver's license issuance or renewal. This means that if you have an outstanding order of supervision, a voluntary departure order, or certain types of immigration court filings on your record, you may now be ineligible for a driver's license in those states, even if you were previously eligible. And driving without a valid license in those states is a misdemeanor. A misdemeanor that, under current federal immigration enforcement priorities, is sufficient to make you a deportation priority. The fourth change is the activation of license plate reader integration with federal immigration databases. In 2026, multiple states have activated or expanded license plate reader programs that cross-reference vehicle registration data against DHS immigration enforcement databases in real time. This means that a vehicle registered to or associated with an individual who has an active immigration enforcement flag can be identified and flagged before the officer even approaches the window. The stop is initiated for one reason. The immigration flag is already in the system before the first word is spoken. The fifth change involves the treatment of driving under the influence charges and their immigration consequences. This is not new law, but it is a newly aggressive enforcement reality. Under immigration law, a DUI conviction, even a first offense, even a misdemeanor, can constitute a crime involving moral turpitude in certain circumstances, making the individual deportable. In 2026, federal immigration enforcement has specifically prioritized DUI-related deportation cases, and several states have revised their DUI statutes in ways that expand what qualifies as a DUI to include lower BAC thresholds for commercial license holders and enhanced penalties for unlicensed drivers. For immigrants who drink and drive, even once, even at a level that would previously have been a minor infraction, the immigration consequences in 2026 are severe. The sixth change is the criminalization of driving with a foreign license beyond a specified period. Most states allow foreign visitors and visa holders to drive on their foreign licenses for a limited period, typically the duration of their visa status or a set number of days, whichever comes first. Several states have tightened the enforcement of this limitation in 2026. Driving on a foreign license beyond the authorized period is now treated as an unlicensed driving offense, not a simple administrative violation. And unlicensed driving in high enforcement jurisdictions is being treated as a basis for immigration status inquiry during traffic stops. If you have been in the United States for more than a year and are still driving on your home country license without obtaining a state license, you are exposed. The seventh change involves insurance documentation and its intersection with immigration status inquiries. Several states now require that insurance documents presented at a traffic stop include the policyholder's identification information in a way that matches a state or federal database. For immigrants who hold insurance under names or identification numbers that do not match a current, valid state ID, a situation that arises frequently when people's legal status has changed since the policy was issued, this creates a documentation mismatch that officers in high enforcement states are trained to flag. A documentation mismatch is not a crime, but it is a basis for extended questioning. And extended questioning at a traffic stop in the current enforcement environment is where immigration consequences begin. The eighth change is the enhancement of penalties for driving with a suspended license when the suspension is immigration-related. In states where a driver's license can be suspended based on failure to provide proof of lawful presence or based on an immigration-related court order, driving on that suspended license now carries enhanced criminal penalties in several jurisdictions. Those enhanced penalties elevate the charge from a traffic infraction to a criminal misdemeanor, or, in repeat cases, a felony. A felony conviction triggers mandatory immigration enforcement review under current federal prioritization guidelines. The ninth change involves the use of traffic warrants as immigration enforcement triggers. In 2026, ICE has formalized a process for using outstanding traffic warrants. warrants issued for failure to appear on traffic citations, as a basis for immigration enforcement actions. This means that if you have an old unpaid traffic ticket, a missed court date on a traffic matter, or an outstanding failure to appear warrant on anything driving related, that warrant is now a usable basis for ICE to initiate an enforcement action. It doesn't require a new arrest. It doesn't require a new violation. The old warrant is enough. If you have unresolved traffic matters in your history, address them immediately. The 10th change is the most broadly applicable and the most misunderstood. It is the interaction between checkpoints, traffic enforcement zones, and immigration authority. In 2026, CBP interior enforcement checkpoints, which operate within 100 miles of the U.S. border and can stop any vehicle, have been expanded in number and frequency. These checkpoints are not traditional traffic stops. They do not require individualized suspicion. Every vehicle can be stopped. Every driver can be questioned. And the question being asked at those checkpoints, "Are you a United States citizen?" is one that requires a careful, prepared response. You are not required to answer that question. But most people don't know that. And the ones who answer it incorrectly, or who produce documentation that triggers further inquiry, find themselves in a secondary inspection that can end in detention. Here is what you need to do to protect yourself. The first step is to obtain a valid, real ID-compliant driver's license in your state if you are eligible to do so. This is the single most effective protection against documentation-based immigration inquiries at traffic stops. If you are on a valid visa that makes you eligible for a state driver's license, apply for that license now. Do not wait until a traffic stop forces the issue. The second step is to resolve every outstanding traffic matter in your record. Unpaid tickets, missed court dates, suspended registration, lapsed insurance. Every unresolved traffic matter is a liability in 2026. Hire a traffic attorney if necessary. The cost of resolving those issues is a fraction of the cost of an immigration proceeding. The third step is to understand your rights at a traffic stop. You have the right to remain silent beyond providing your name and required documentation. You are not required to answer questions about your immigration status. You are not required to consent to a search of your vehicle. You should never lie to a law enforcement officer. But silence, polite, calm silence, is a protected right. Know it. Use it. As 2026 continues and enforcement coordination between local and federal authorities deepens, more traffic stops will produce immigration consequences that the drivers involved never anticipated. But you don't have to be one of them. Knowing this does not make you a criminal. It makes you smart. It means you're prepared. It means you're protecting your family. Share this video with every immigrant driver you know. It might be the information that keeps a traffic stop from becoming the worst moment of their life. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase of U.S. immigration enforcement unfolds.